stand. It's kind of getting a reputation like Calvert Drive-In. Come out and eat and get a hamburger sometime, you'll like it. So that's what funds our park: fees, concession stand, and whatever donations we can get. We do a little bit of advertising on signs, but it's, you know, a couple $100 here and there. And I do have, if you folks would like a copy of our P&L statement for the past 12 months, you can see where the money's going. Take a look at it.
Sure, I'd like to get that. Right.
If there's anything you need from us, you know, let Jeff know. Jeff can get in touch with me or Terry Massa, and we can get you whatever information you need. But once again, I want to appreciate everything we get from you guys, and it's been a real support to us. So.
You've made our job easy. Thank you.
Thank you. Thank you. Good presentation. Impressive. All right. So, what do you? How about if I with Steve put together some sort of a form or something that we can gather this information, have it organized for each group.
I think we have a form. Isn't there a certain form you've all filled out?
There's a request for funds that we fill out. It is got a form number and whatever on it. We fill that
Somewhere
out.
we've got one.
Basically, it asks, what are you going to do with this money? We have in the past turned in receipts equivalent or greater than the $10,000 that we were requesting for.
Okay.
Yeah, I think the things we need to know how much money they have. I mean, that's the big issue, right? Is whether we're going to give $10,000 to an organization that's sitting on $1 million in their account, and that's what I want to make sure we're not doing. And I'm convinced you don't have $1 million. And I'm convinced that you.
If we had $1 million, we wouldn't have that big creek running through the middle of the ballpark, and we'd have metal light poles and all kinds of neat stuff.
Okay.
And then we wouldn't have $1 million.
But I'll be happy to help develop. I think I forwarded one that a local charity uses and what they require.
Okay.
Yeah, we can take a look at the form we have. You can just update it.
Okay. That sounds good.
Sounds good to me.
All right. Then we'll come back next meeting. Maybe we'll have sufficient information to.
Well, I can tell you that if you're looking at page 2 of Steve's report, I'm comfortable with all of the numbers that he's got suggested in the appropriations, which
I would say most of these on the list that we filled in, Steve, most of them have asked with a form or have contacted the county judge's office, haven't they? I'd say the biggest part of them.
Yes.
I mean, I'm good with what's on here too, and I
are
think.
you looking at page 2 or page 1?
I've looked at page 1 and 2. I mean, that's.
Because that would leave Lone Oak, Heath, and Reedland at 10,000, right, Steve? It would add $7,500 for Brooks Stadium. It would add $25,000 for CASA, and then it would add money for 911, which we absolutely have to do.
Now, when you're saying add.
So it would essentially add $429,000 in spending to our present budget, of which, sadly, $250,000 would come from the piggy bank. Am I saying that right? It says fund balance, but that's essentially our savings account. So the $429,000 would be offset by the $42,000 we got from CAECO and $137,000 we got from the June occupational tax.
So y'all are comfortable with not having the information we're talking about getting?
Well, we've got these guys' information. Yeah.
Well, yeah, but they're only one.
But what's not included in page 2, what's not included is senior citizens is not included, PATS is not included, Lone Oak Tennis is not included, Paducah Civil Air Patrol is not included, and the McCracken Civic Beautification is not included, and the Veterans Van is not included, and the Community Career Endowment is not included.
So you wanna raise it by 24%, is that what you're saying?
Raise,
The budget? We went from 683 to 845. That would be fully funding everything.
we won't be fully funding everything. I'm suggesting that we follow what's on page 2, and we account for the additional income we've got. And we recognize that we've got to dip into the piggy bank some more because we have to fund 911 and the other, well, we're only adding really 2 nonprofits there. We're adding Brooks Stadium and CASA. The rest are county needs. Includes a jail, a new locks project, $26,000. Computers and networking, Steve, $35,000. You'll have to speak to that. And then you've got $49,000 for contingencies. I guess I can't speak to that.
Well, that's to take care of the unanticipated things that come up, and you could have some dollars available in that to allocate to some of the other outside agencies that you've yet to agree to fund at any level yet. So it could be used for that. The going back to budget time, we had about $81,000 worth of computer and IT infrastructure. We had
Say that again, I'm sorry.
$81,000 in IT and network infrastructure needs. We have 28 computers our employees use that are 7 years old or older that need to be replaced. We have some legacy systems that we're going to lose support on that we desperately need to address, and so we just need another $35,000 for that to come from those budget adjustments.
So the $49,000 in contingencies, would we be approving that spending, or is that spending that would come back to us before we spent money on the contingency?
We'd come back to you on what you would use that for.
So that
We
discretionary fund, or I guess,
we never spend a contingency without a court order.
Court order.
We'd come back to you.
Have we heard from CASA and Brooks Stadium?
CASA's been here.
I know they've been here, but since we indicated since the budget year began, have we heard from them?
Yes, and Brooks Stadium as well.
I've met with the director. Will you and I both had an opportunity to meet with the director of CASA? I think we got our bang for buck from them when it was more. And I guess that's always been my concern, is we kind of, because they were at 45,000, weren't they?
Right. Well, I'm okay with that. I just think these guys need to come in front of us if they want to ask for money. Look at like proper paperwork, like I said, make sure they're not sitting on a ton of cash.
CASA is affiliated with which organization?
Child Watch.
Child Watch.
Child Watch had a pretty substantial, I don't remember what it is now, they have a pretty substantial.
I remember you looked that up in the last,
Yeah.
in that meeting as well. They did have an answer for that, in that some of that was designated funds. I don't recall the answer immediately for it,
These are all good organizations. They provide a very important service to the citizens of the county, but we, as you said, we just need to make sure that we're not giving them money so they can maintain a deficit that's more than what we've got, or a surplus of more than what we've got in the county.
I agree. I guess I presume a little bit of diligence, safety with the CASA, just because we're going down from 45,000 to 25,000. If it was a good decision at 45, it's got to be a great decision at 25. I guess, but I think we need to continue to.
So do we need a motion to?
I don't think we need to do anything just yet. Unless you've decided on CASA and Brooks Stadium, if you can put that one to bed, and if we had a motion to increase the outside agency's budget by 32.5, we will incorporate that in a later court action in the form of a budget amendment. Or you can just wait for the budget amendment to occur. Either or is fine.
I don't think any one of them just a slam dunk myself. I mean, here, we do have, we have the numbers in the presentation from Lono. Maybe there is one, but I'd be much more comfortable to have the information on this form, whatever either one you have or amended from, get that information. And what we can do, we can send it out to everybody and have time to look at it, and come back, perhaps we'll be ready by the next meeting and see if we can make a decision. I don't know how long I'll need to present whatever. Do we have a meeting again in 2 weeks?
We do.
But you already have one on Brooks Stadium and CASA, right?
Well, we received very good information from Brooks Stadium, very comprehensively done, in written.
And were they exorbitantly rich, or?
No.
I just like, I don't care when we make it official, but I'd like to give these people some type of direction that, just like these guys sitting out here, yeah, we're gonna get your money, we just want to do it a certain way. Same with Brooks and CASA, and, you know.
I'm not so sure that we can get the people contacted and get the information in and then get it out and then make a decision within 2 weeks. Do you suppose is there
We can make that a goal. We might as well start the process.
All right. Well, we'll shoot for it then.
Okay.
Try to get it out this week and get the information, get it to you guys as soon as we do, and then we'll be better prepared.
It's gonna be a long meeting in 2 weeks, and everybody shows up their hand out there.
Well, I guess it's I think we're comfortable committing to Lono. I mean, well, I don't know. I guess I'm speaking for me. I'm comfortable committing to Lono. I don't want these guys to have to come back.
Yeah, they've already done the presentation.
Well, and I know you said have them come before us. I'd be certainly comfortable. I used to tell the lawyers in court, I read at least as well as I hear, and I can read at home. I mean, if you don't think you need people to come here and be physically present and stand up here and
I think as long as they get the paperwork,
I like
correct,
paperwork.
we're good.
We'll go through that. I would say more than half have adequately filed documents with the court.
Okay.
I think if we can get that paperwork, if we can get copies of it ahead of time, so we can look it over, then if we have questions, we get the questions
Okay.
answered, or at least
All right.
asked before
We
the
can do
meeting,
that.
and if we need somebody here.
We can do that.
You know how much we spend, don't we pay for the lighting at Reedland?
Yeah, you asked that before, and I think we determined, and Pam, step on me if you need to, I think the combined expense of electric costs in Reedland and Heath are right at $25,000 a year. We do
I
not
think we
pay
need to take that
Lono-
into consideration too,
because
because you're paying your own electric bill. We're not paying Lono's electric bill.
Lone Oak owns their fields. McCracken County Fiscal Court owns the ball fields at Heath and at Reedland.
I know we had discussion on that a year or two ago, that if somebody else is paying the electric bill, sometimes they might not flip the lights off
Well,
on time, and, you know, that
I think
could
I
be an
heard them
issue.
say 14,000 on electricity at Lone Oak. Well, if we're 12 and 12 at Reedland and Heath, I would say we're in line. Their operations are, I'm going to guess, a little bit smaller than yours each. So,
Quite a bit smaller.
So, I don't think it's out of line. Might be a little high, but not terribly out of line. And at both and at Reedland, That does include, I think, or at Heath, we have the community center out there that the county rents. So it's a little hard to, all on one meter, it's a little hard to separate that out.
Anything else on that? All right, thanks, Steve. All right, and then we have for discussion, the omitted property tax. I sent a memorandum about that to everybody, and our county attorney assisted with that, and I put together some information about how the statutes, Kentucky mandate that we recoup the tax revenue from what's called omitted property. That's the property. We're not talking about the under-assessed property, the property that had a value placed on it, but it was just way low, like many millions, maybe billions of dollars in McCracken County were done. But we're talking about property that has never been on the tax rolls at all. And so this is property that the statutes require that a person, you got a $10,000 lot, and then a year later you build a $500,000 or $250,000 whatever house on there. The property owner is required by law to report that to the local government, to the PBA, so that it can be assessed and taxed based on that assessment. And so these are properties that were never, as the law required, reported, and so never taxed. And the law requires that we go back and capture that, and not only capture it, but capture it for a 5-year period. There's also the provisions for penalties for those people who self-report, a 10% penalty. Those who do not report and are still lurking in the bushes or whatever, a 20% penalty can be imposed. And then there's a mandatory 12 or 1% per month or 12% per year fee on that, interest on that, 1% interest per month. And so I personally think we have no choice but to do that. I've talked with Bill Dunn, and we can invite Bill up here in a minute. Our talk has not been only just about, and I think Bill in our discussions realizes that it's necessary to do this, but we're also looking at ways that we can do this without or at least lessening any hardship that might be on people who have omitted property they never reported during the tax rolls. And so what I think, and I believe you all will agree, we want to not force people into foreclosure of their homes, losing their homes. As a law judge, I see in the past many times people that can't pay their taxes or don't pay their taxes. They're going to delinquent tax rolls. Lien is placed against their property, and then certain companies come in and buy the liens. They generate huge, in my opinion, fees and legal fees, various other fees associated with that, and soon a $1,000 tax bill becomes $2,000 or $3,000 or $4,000, and then that's how they make their money. And so I'm going to propose at least that get with the county attorney at some point. There wouldn't be a tremendous rush, I think, on it, but to determine, do we have some wiggle room? Can we get creative? Can we make these, if we do, and we'll have some people, I would guess, that would say they can't pay those taxes from a 5-year period, along with possible penalties, along with the interest. Can we make these liens unattractive to purchasers so that, and perhaps give extended times for these liens to be paid, or extended times before we would put a lien on the property. I would be interested in looking at all possible ways we could go about to do that. But because these are properties that folks have not paid any tax on, because they, under the law, were required to report these improvements and never did, and because their neighbors, everybody else, because this group of people didn't pay their taxes, they enjoyed all the services of the government, the library, the schools, all the fire departments, etc. But they paid nothing toward them, and so in economics they call that free riders. And so I feel like we're obligated. I know we're obligated by the law. I feel like we're obligated by just fairness that those folks be required to pay up what they should have, and we will recognize, of course, that the people who have been paying their taxes have been paying at a higher rate because this group did not pay anything. And so we'll get that seesaw level, balance that scale, and so that's on for discussion. I'd like to see what your thoughts are. I also have a proposed order here, if we believe we can agree on it, that would authorize me to pursue the collection of those taxes consistent with that legal memorandum. I don't know if I'm not sure that we got copies of the proposed order. Just says it's ordered the county judge executive authorized to proceed with collecting taxes on omitted property consistent with the memo issued by the county judge executive September 6th. We may or may not get there right now. I know that Mr. Dunn's here. He's told me he's been sending out letters to the owners of property, both the under-assessed properties and the omitted properties as well. And of course, the under-assessed ones are just the ones that the PVA, prior PVA, just didn't do the job, just didn't assess those properties, or they were last assessed 20 years ago in various ranges, 10, 15, 20, some even longer ago than that. Law requires they be assessed annually, and certainly that wasn't done. Assessed annually, inspected every 4 years. But we can discuss it now, or we can hear from Bill Dunn. We'll hear from Bill, see what he's got to say first. Want to say a little something, Bill? Bring us up to date. You said the list was growing daily.
Yeah, 2 hours ago I had another gentleman come in and volunteer his house. He built it 6 years ago. And just by looking at it, I'd estimate it's probably around $250,000. Nice big brick home in the fire district.
That's the assessment.
Yes.
Okay.
Yeah. Of course, my guys haven't been out there yet. That's just my rough estimate just from looking at it on the aerial. My guys will go out there tomorrow morning and measure it and get the specifications and characteristics, and then Glenn will put a number on it in the next few days. But anyway, every time I find one of these, I hope this will be the last one, but then a few days, a week or two later, we find another one.
How many omitted do you have now?
Well, I wasn't keeping track. Did you tell me there was 32?
No,
23?
20 was 23, and if that one's this afternoon, that'd be 24.
Yeah. We removed one or two from there. One of them was an accident. from my mapping staff a few years ago, so we actually removed one of those. It was on Monroe, I believe it was. And the one, I don't know, the one with the tower, you remember the tower that we added for 1.3 million? We haven't really discussed that one very much, but I question whether or not that's the taxpayer's fault. That was converted to tangible property in 2003, I think it was. I question whether or not that should be classified as omitted, because that was the PVA office's fault. So we still got that one.
So it's listed as tangible property
Yeah,
rather than...
this was, you remember when the cell phone towers were being built about early 2000s? There was some miscommunication, misunderstanding, lack of knowledge as to what to do with those. Are those tangibles? Are those real property? I suspect it was in error converted to tangible property, and it probably should have been taken back and put on the real property list about a year ago, about a year after that, before a true valid decision came down from the Department of Revenue, and it was never put back on as real property. We did verify that it should have been on real property about that same time, and we just, found it. So anyway, it was just a mistake.
What's the difference in the net tax received? In our tangible property tax rate higher than the real estate property?
I don't have those numbers off the top of my head, but...
So they paid the tangible property tax. They paid that the entire time? Or was it taken off the rolls when it was taken off?
I think it was taken off completely myself. I don't think I'd have to look at their tax return to see, or their tangible return, to see if they were even putting it on there. After we put it back on the real property tax roll, I mailed them a letter like I did everybody else. We haven't heard from them. I don't know if it hadn't gotten to the right person, they didn't get it, or maybe they're not disputing it. I don't know.
They're at the law office where they are.
So you've got roughly 25 omitted properties.
Yeah.
Maybe a few less or a few more.
Yeah,
And how much of the county have you surveyed?
very little. We did all the farms. Farms were about 1,900 properties. And the other two fire districts that we've completed were maybe 1,000 properties. So there's maybe 2,900 out of about 34,000. So we've still got about 31,000 to go.
You're about 10%. You got 25.
Yeah. And these properties are all over the county. They're not in one specific fire district. They're all over the county.
Do you think you're going to find more omitted properties, or have you done enough work that you think you've found 90%? I mean, there's probably one or two out there you might not.
I suspect we're going to keep finding them.
Do you think you found most of the omitted properties?
I don't have any idea. I honestly can't answer that question. Literally, every time I find one, I hope it's the last one. And then we find another one. To my surprise, that gentleman walked in literally 2 hours ago and told me. We looked it up, and sure enough, it looked like it was a $250,000 house, 6 years old.
Well, we need to put him on the attaboy list.
Yeah. I have to say, he was very concerned. He was afraid he was going to have to sell his house over the interest alone.
All right, so $250,000 house, county tax bills
Roughly $2,500.
Per year?
per
Yes.
per five, so it's about a $10,000 debt.
Yeah.
So what was the reason why he hadn't come forward before now?
Didn't get into that. I couldn't really answer that question. But he did throw in the fact of what some other people have said, that they said it was in their escrow. It was in their escrow. In their escrow.
Yeah, and I don't know that we, as I read, the judge has done excellent research on this, and I mean, we don't get all this tax. I mean, we're talking about the library, we're talking about the school board. I don't know that we're empowered.
We're a small amount of it.
Huh?
We're a small amount of it.
Yeah, we're a small amount of it. You mentioned the statutes. just Section 3 of the Kentucky Constitution says that no property shall be exempt unless there's a particular provision, and none of these apply. I don't think we're empowered to forgive a constitutionally imposed tax. I think it'd be against the law for us to try and forgive it. I do like the idea of your plan of working with Sam to make sure that these tax bills don't become attractive to the sharks, and finding some way to keep people from being the victim of the sharks.
That's one thing my staff has told me repeatedly, that when these sharks buy these tax bills, their tax bill goes up significantly, as you guys well know.
Yeah. In fact, today, Steve and I were kind of spitballing, trying to figure how it would be, because we are hearing that the homeowner, property owner says, well, I paid my PITI, my principal interest taxes and insurance to the mortgage holder, the bank or whoever, and so I just assume it's being paid. We made contact with, and don't have the answer yet, from a real estate lender about does that, as they would say, hold water. To me, I don't understand what if you go in and you get your mortgage. I need $200,000. I want to build a house. Okay, here it is. You want to pay taxes and insurance yourself, or you want us to pay it with your principal and interest? You pay it, PITI, and so you pay all that to the bank, and the bank is responsible then for paying that out. Well, what is the bank doing when there is no taxes, because it's not on the tax roll?
Well, I can tell you, I get a letter every year. Mine's off a little bit, up or down. I mean, you get a refund, or
Yeah.
I mean, it's sitting there. They let you know it's in escrow.
Well, my hunch is, so they're still getting a bill for that real estate
Yeah.
without the improvement.
Yes.
So they're getting a tax bill for the $10,000 lot. They're just not getting a bill for the $300,000 house that's on the $10,000
Right.
lot.
The example, the gentleman that came in 2 hours ago, he was getting a tax bill on an assessment for $18,000.
How much?
$18,000 of land.
So
It was like half an acre in subdivision.
it's just gone back to, I mean, what's happened is that Nancy did her PVA assessment at the time of the deed, and that's it. She never went back at the.
That's right.
Never looked at the building permits, never looked at the completed projects.
That's the reason why the commercial property is in awful shape.
But the point I'm making is the bank is receiving a check from the homeowner that includes whatever amount, $50, whatever a month toward the taxes. What is the bank doing with that money? They're not paying it to the bank, I don't guess, or if they are, what's the bank doing with that money?
I bet they
And
make
then at
sure-
the end of the year, when you file your income tax and you're gonna take as a deduction on your income tax, your taxes, why'd you put 0? Or why did he put 8,000 on a $260,000 home?
I agree with you that in the right scenario, the average person that owns a $300,000 house would have numerous opportunities along the year to figure out, hey, I'm getting a real deal here.
And the insurance usually tagged with it, so I guarantee they're not going to have insurance on that.
If it's a $40,000 house, and I can see actually where it might get missed, but at $300,000, it's hard.
And then, as I wrote in the memo there was the question of what is the line between underassessed property, that is property that just was assessed at a far less than fair market value, and omitted property. And so at some point, you've got the land, say the land's worth $20,000, and you build even just put a barn on there that's worth $40,000, you've doubled the value of the land. The statutes say that a omitted property, if Sam and I, the county attorney and I, he helps a lot with that, of determining what is the dividing line between the underassessed property, and at what point does it become the improvement eat up, in essence, the base. And there's plenty of law that would say that certainly a 50% improvement in property qualifies as omitted property and makes it subject to the penalties and the interest, as opposed to if it's less than 50%, it's just underassessed, and and the important part, of course, that we know is that the underassessed is capped at the 4% by that House Bill 44, so we can only get a small amount of that each year. But the omitted property is not capped, it's new property, and so we would receive the full value of that money. And I think 50% is extremely generous to the property owner. I think the term is significant improvement, or was it, maybe it was substantial. I don't remember the word, was it significant, or I think it was significant. That if the property has a significant improvement on it, then it becomes omitted property. Certainly 50% gain is significant. I think probably 25% would be significant. But so I just kind of propose that we go with the 50%. I think we'd be justified in saying 25%. But,
is there anything in the law or any Attorney General's opinion that addressed that issue?
yeah, I put them in there.
Well, I haven't read all of it. What did it say about the omitted, and is it 25%, 50%?
It was, there was a case, and there was an Attorney General's opinion, and it just kind of, there's no real clear line there.
Yes,
but it suggests that certainly 50% would be significant, but I think we could, I mean, it's just not been clearly answered, in my opinion, I think in the county attorney's opinion. But certainly I can't imagine that somebody would seriously argue that if we're saying a 50% increase in the value of your home by a house or a barn or whatever, that they would say that's not a significant increase. Yeah.
Okay. Well,
so I don't know if
I'm prepared
discussion on it, or?
I'm prepared to make a motion and authorize the pursuit of the tax. I think we have no choice but to do that. It's a violation of the law if we don't do that.
I'll second.
All right. Any further discussion? And so the motion, are you good with that order?
I'm good with that order.
Read
So
that.
it is ordered.
Yeah, I don't have it.
Here, I'll get it to you. Yeah. Let me read what it is now. It is ordered, and we'll just put that with your paper there. It is ordered that the county judge executive is authorized to proceed with collecting taxes on omitted property consistent with the memo issued by the county judge executive on September 6, 2019.
So that would include all omitted property found even after this motion, is that right? That'll include any omitted property found, even if it's found after we approve this motion. Okay.
But yeah, I think we need to do it because you can't really give anybody a bill. I think there are people out there that want to pay their taxes and they can't pay it until we do the bill.
Yeah, I have a process I have to go through to fulfill my part of this. I have to send them a assessment notice telling them how much we've set their assessment at. They have the opportunity to debate it, come in and talk about it. They can take it through the chain, the Board of Assessment Appeals, the Kentucky Claims Commission, as high as they want to go. And then we have to send the letter over to the county clerk's office where they prepare the bill and mail it.
Oh, and also, I believe, I sent a memo, I think, to you guys that I spoke with, what's the guy's name?
Tom Crawford.
Tom Crawford in Frankfurt to oversee the regional rep or something. And I was loaded and prepared, but didn't need to go on the attack. Suggested to him that it was the revenue cabinet's mess, this tight spot we found ourselves in on all this underassessed and omitted property. I can't say he agreed, but he did say that he saw what we're talking about and that he's going to, he says, have 2 or 3 people from outside of in the agency to come into Mr. Dunn's office to assist him in identifying and assessing these properties that are both underassessed and the omitted ones. And so that'll be a help. I guess they'll focus just on those things, and maybe that 2 or 3 years you thought maybe it'll go down to.
Yeah. Well, then after that, it's the hardest part, in my opinion, is reviewing everything. There's a lot of work in this that we just don't have enough people to do. Reassess the whole county review the whole county every 4 years. We need a lot more people than what we've got.
So, all right, we got a first, a motion and a second. Any other discussion? All in favor, aye.
Aye.
Opposed, no. All right.
I have another question too. I think there's some confusion among some of the taxpayers that those that have underassessed property, that they're going to have to pay back taxes for 4 or 5 years. That's not the case, right?
That's
They'll
right.
only pay a higher tax once it's reassessed. Going forward, they won't have to pay for any underassessment in the past.
That's right. I'm glad you brought that up. There's a lot of people that misunderstand that they think they're going to have to pay 5 years of back taxes
Right.
because their house is.
Right. And it's only those that were omitted to pay back taxes. Those who were underassessed do not have to pay back taxes.
That's right. That's right.
I was accosted in Walmart about that
Were
a
you?
couple days ago. So,
Yeah.
and I tried to explain to him, but I won't repeat what he said.
Oh, and so what I wanted to make sure that the public understands is we're trying to, well, we're going to do what the law requires us to do, and fairness requires us to do. If folks know or suspect they may have omitted property, that means property that's increased in value over 50% or more even over the years, and they want to not get that 20% penalty that they're subject to be imposed. Do they call your office? Is that what they should do?
They can call the office or they can come down and speak to me personally if they want, or anyone in my office.
Okay. And so they can call or come down to the PVA office, ask, say, I've got this concern. And if they ask, bring it up themselves, we would certainly not seek that 20% penalty. And so that could save them quite a substantial amount of money. All right.
I have one more quick question. Does omitted property, does that become new property in calculating House Bill 44?
In my opinion, it does, yes.
Pardon me?
That's the way I'm putting it in,
Okay.
yes.
So the omitted property, we benefit from that.
Yeah.
From the underassessed, that's what reduces the tax rate when they calculate it, because
Yeah,
values go up, and when the 4% limit, that should lower the tax rate.
Yeah, there's part of our software when we put in the omitteds. We put it in for the first time. We put it in as an addition.
Okay.
So it's my understanding what you just said is correct.
Okay, good.
Yep.
Thank you.
So I'm curious as to if there'll be a point in time, because it sounds like you'll eventually hit a point in time when you'll be able to say to everybody, if you had a $200,000 house before I was your PVA and you've still got a $200,000 house, the good news is your taxes have gone down.
Right,
We're headed toward that, right?
that's right.
And we probably don't know if we're there yet.
No,
Theoretically, that's what should happen.
yeah, there's a lot of people that are overpaying, and there's a lot of people that are underpaying.
So we're not that far off from that, the way, as quick as we're going.
Say that again?
We're not that far off from where it will drive the person that's paying the right amount, taxes down.
Well, from my point of view, we've got a long way to go for reviewing the whole county.
But once you hit that 4% and go above it, it starts working in the opposite, coming down, correct?
I think so, yeah.
If you get to a third of the county and.
Oh, yeah, every year should make a difference.
Yeah.
Yeah.
Okay.
And I just don't want it to be said that people, we know we got like 12 people, I think, watch this on live TV. My wife, your girlfriend. But
I don't think she's watching anymore. She watched first couple.
she probably got tired
I think we lost her.
but it may be in the paper, it may be on TV, that sort of thing. This meeting, I think the message needs to be, you need to get yourself to the PVA office or call there and say, hey, I've got some question about this, and we will consider that as you've done your diligence. You can avoid a 20% penalty on your tax bill going back as far as 5 years on that. Now, there's also, and I think I put in there about there is actually a punitive, a criminal penalty for that can be 3 times the tax bill for those who intentionally provide false information or intentionally avoid giving information. So those folks are subject to 3 times their tax bill, which could be just a tremendous amount of money. And so we're offering this. It's sort of like when you have overdue library book, bring it back within a certain time, won't do much to you. But I'm for, and I think what we're doing here tonight would be those folks who want to bury their head in the sand, want to not report. I think, well, as one person you already said, Bill, said, hey, it's your job to track me down. It's not my job to report. That's exactly the opposite. The law requires that any person that builds an improvement or puts an improvement on this property to report that to the PVA. So, yeah, there's that.
I think another thing, too, I think we need to apologize to all the taxpayers in McCracken County for what's happened. We have no oversight. There's no oversight of the PVA office in what happens. The Department of Revenue does, and they have a formula they look at, but we had no way of knowing that these tax assessments were in such poor shape. We've had meetings over the last 4 years since I've been on this fiscal court with the PVA, and she assures us every time that she was doing her job, that property was being reassessed every 4 years, and that the assessments were accurate and correct. And we had no way of going back and looking at any records to see if it was inaccurate or whether it was or wasn't properly assessed. And all the taxpayers in McCracken County have been penalized for it, because if it was properly assessed, that would affect the tax rate of those who have the proper assessment. So I think, although there's no way, I don't think there's any way we could have prevented this problem or have seen this problem as members of the fiscal court. I think I just want to apologize to the citizens that this happened. And I wish there was some way we could make the previous PVA accountable, but she's probably not available because she's in jail.
Along that line, I'd like to add one thing to that. I've tried to be as transparent as I can, open and transparent. I've added a transparency section to my website. If anyone has any questions about any of this, feel free to come by my office, call me on the phone, do whatever you want to do. I'm happy to answer anybody's questions.
Thank you.
All right, thank you, Bill. All right, let's see, do we have any old business to previously tabled items? I don't know of anything. Then court orders, we got a number of court orders to do. Madam Clerk, you're gonna earn your money.
Yeah, but I'm going to take a break for a minute, if that's okay.
Oh, okay, all right.
Okay.
Let's take a 5-minute break then. 5 minutes? I guess 5 minutes.
County Judge Executive to request funding for elected officials to attend the October 17th and 18th Oak Ridge, Tennessee trip from Pack Road.
So made.
Second. And that'll be just to cover the actual expenses, right? The hotel and meals?
Yeah, and I also wanted to throw out this. I've had requests for, this got whittled down from, there was a request that we fund everybody that wanted to go. And I told the individuals that we weren't going to do that, community members and, well, not everybody wanted to go, I guess, but there was quite a group that were lining up to go on this trip. And so I wanted your inputs on certainly the four of us, and I meant for it to say the deputy judge executive as well, as we could maybe amend it to say the deputy judge executive, if you're good with that.
So
But
would
also,
it be the judge, the three commissioners and the deputy judge? Is that what we pay, or would we pay the city elected officials too?
well, that's the other thing. Do we want to include and pay for, out of our PAC row account, all of the elected city officials that want to go? There's 5 of them, and possibly their deputy or city manager, Jim Hart. Do we want to do somewhere in between?
Does the city get any PAC row funds?
No, it's county. Of course, there's always a middle ground of, we could do like maybe the mayor and the city manager, or we could leave it just the county folks.
I personally think if it's elected officials, we go ahead and pay for all of it. I mean, I either pay for all of it or pay for none of it. I don't want to pick 2 or 3, you know.
And I don't know if all 5, or what's your thought on, Mr. Parker, on the deputy judge and the city manager?
Well, I think they play a big role. I absolutely think they should be involved.
What do you think? We could make it,
I guess, yeah.
Elected officials, both city and county, and again, I don't know how many want to go, and the deputy judge executive and the
City manager.
City manager. And I suspect there'll be maybe 1, 2, 3 that won't care to go, but.
Unless my schedule changes, I won't be able to go, but
Okay.
I'll take good pictures.
We'll take good pictures and good notes.
We'll
I don't
tweet
think
it.
you're allowed to take pictures of it.
We'll tweet it.
So maybe the easiest way to do those things, I know we're getting these things, well, we got to vote on that. And if Mr. Parker wanted to withdraw that motion and make a motion of what you just said.
That we include the city elected officials and the county judge, the assistant county judge, and the city manager.
Okay. City and county elected, city manager and deputy judge.
Deputy judge.
Are you just amending this one to do that?
Oh, he withdrew the other
He
one.
was, yeah, to
You
back up,
withdrew the
then we
first.
do it again.
Have we voted on it already?
Well,
So
Do
we
we vote on it?
withdrew this
that one.
original order.
Yep, and I'm gonna make a motion that we ask for money from PAC Road to pay for city, county, and city officials, the deputy judge executive, and the city manager.
Yeah, and you had a question, well, okay, so is there, that's the motion, is there a second on this?
Is there a reason we should say fiscal court members, city commission members, the city manager and deputy judge? Is there any reason why we need to do that? I mean, suppose the
Just watch it on the
Supposed to
tape.
elect-
sheriff decides he wants to go.
Oh, I
I
see.
don't know. There's only 5 elected city officials. but
Commission
there's-
members.
Who made the motion to withdraw?
I did.
Okay, and who seconded it?
I don't know.
Eddie
I may be
But I don't know,
mistaken on it.
if he withdrew, does he need a second if he withdraws his motion?
Okay, So
think
just
I
the
think
motion to
he
withdraw.
withdraws.
Yeah.
You did that.
So the new one will say county officials, county commission members,
Yep.
city commission members, deputy judge executive, and city manager. They got it?
And the mayor and the county judge.
Well, the mayor's on their commission, so,
Yeah,
and the county judge is on ours, so we're
Yeah.
covered. Okay.
okay.
All right, so that's my motion.
All right.
That's second.
That's-
We know what we want to do anyway.
Second. I'll second it.
All right, any other discussion? All in favor, aye?
Aye.
Opposed, no? All right, do that. And then B.
It is ordered to approve the following 2019 tax rates as set by the boards of the taxing districts. County real estate .1010, tangible property .1421, health .024, tangible .024, mental health .012, tangible .012, McCracken County Extension Service, real estate .04087, tangible .110483, McCracken County Public Library, real estate .061, tangible .0841, Paducah Junior College, real estate .016, and tangible .016.
So moved.
Second.
Any discussion? All in favor, aye?
Aye.
Opposed, no? That carries.
It is ordered to receive the following 2019 tax rates as set by the boards of the taxing districts. McCracken County Schools real estate .538, tangible .538. Concord Fire District real estate .075, tangible .075. Hendron Fire District real estate .0755, tangible .0755. Lone Oak Fire District real estate .047, tangible .047. Melbourne New Hope Fire District .043, tangible .043. Reedland Farley Fire District real estate .071, tangible .071. And West McCracken Fire District real estate .069 and tangible .069.
So made.
Second.
Any discussion? All in favor, aye?
Aye.
Opposed, no? Carries.
It is ordered that the following resolution be adopted. A resolution levying the tax rate for the year 2019 for taxes to be collected for the benefit of McCracken County, Kentucky. Be it resolved, the Fiscal Court of McCracken County, Kentucky for the calendar year beginning January 1st, 2019, levy a tax rate of .1010 on each $100 of value on real estate and a tax rate of .1421 on each $100 of value on tangible property located within McCracken County and assessed by said county and by the Kentucky Department of Revenue, and that taxes further be levied at a rate of .025 on each $100 of value on all bank shares located within said county, and that taxes further be levied at a rate of 0.00 on each $100 on all unmanufactured tobacco.
So ma- oh, I'm sorry.
That's okay. Be it further resolved, the revenue raised by the foregoing levy be used for the maintenance of county government, care of paupers, the upkeep of public records, public roads and bridges, and all other general expenses of McCracken County as required and allowable by law.
So made.
Second.
Any discussion? All in favor, aye?
Aye.
Opposed, no? Carries.
It is ordered that the following resolution be adopted. A resolution levying the tax rate for the year 2019 for taxes to be collected for the benefit of the McCracken County Health Department. Whereas the McCracken County Board of Health, on behalf of the McCracken County Public Health Department, has requested the McCracken County Fiscal Court to impose by resolution a special ad valorem public health tax in the amount of $0.024 per $100 of assessed valuation of real estate, and tangible property in said county as of January 1st, 2019, which is in addition to all other ad valorem taxes. Be it resolved that this tax hereby be levied.
So made.
Second.
Any discussion? All in favor, aye.
Aye.
Opposed, no. Carries.
It is ordered that the following resolution be adopted. A resolution levying the tax rate for the year 2019 for taxes to be collected for the benefit of the McCracken County Mental Health Center. Whereas the Western Kentucky Regional Mental Health and Mental Retardation Board, Inc., on behalf of the McCracken County Mental Health Center, has requested the McCracken County Fiscal Court to impose by resolution a special ad valorem mental health tax in the amount of 0.012 per $100 of assessed valuation of real estate and tangible property in said county as of January 1st, 2019, which is in addition to all other ad valorem taxes. Be it resolved that this tax hereby be levied.
So made.
Second.
Discussion? All in favor, aye.
Aye.
Opposed, no. Carries.
It is ordered that the following resolution be adopted. A resolution levying the tax rate for the year 2019 for taxes to be collected for the benefit of the College Support District. Be it resolved, the Fiscal Court of McCracken County, Kentucky, for the calendar year beginning January 1st, 2019, pursuant to Kentucky Revised Statutes 165.175, levy a tax rate of .016 on each $100 of value on real estate and a tax rate of 0.016 on each $100 of value on tangible property, except all inventory, located within the College Support District, which consists of all property in McCracken County, outside the city limits of the City of Paducah, and that taxes further be levied at a rate of 0.025 on each $100 of value on all bank shares located within the College Support District.
So made.
Second.
Any discussion? All in favor, aye.
Aye.
Opposed, no. Carries.
It is ordered that the inventory tax portion of McCracken County general tax be re-implemented.
So moved.
Second.
Second. Any discussion?
Yeah, so this just seems lightly worded. Is this going to be followed with a more formalized ordinance, or is this all that we need?
Well, in one of these resolutions, the one from McCracken County, up until this year, it took an exception in the resolution to inventory. So when you read the resolution, it didn't take that historical. Julie, am I saying this right? In the resolution for the benefit of McCracken County, it went to some length at the part where it talked about tangible, and then it said, comma, except for inventory, comma. So we struck that language out of that resolution. That's number D, I think. And then the treasurer, in consultation with Kathy in the clerk's office, thought to clarify that point, we'd have an order making sure everyone understood that was re-implemented.
I see. So when we passed D, we basically
You passed it.
The inventory is not accepted, and we're just clarifying it with H, with the exception of G, which does accept.
Correct.
Why G?
Didn't have any direction on that.
Meaning that's not our tax, that's the college.
We set that tax, but
Oh, we do set that?
yeah, but it wasn't discussed and at all. It never came up in discussion, so it can be added at any point in the future.
I see.
So is this a self-reporting thing, or?
No, it is not. There are assessments and there are tangible forms taxpayers fill out, and it's part of the certified assessment that the state does.
Okay.
It looked like there was 240 million in assessed value in inventory.
Well, I guess I want to go back then to G. And so G is our tax rate on all property within the college support district.
Yeah, there's two.
And I
There's
don't
two
get it.
college sport districts. There's one in the city and there's one in the county.
Who lives there? I guess I don't know what the college support district is.
There's two college sport districts, and one is more or less the city limits of Paducah, and the other one is McCracken, everything outside the city limits.
So
We
it's
set the rate for what is outside the city limits.
Is this one of those special taxing districts? Is that what that is? It gets me, who gets the money from G?
PJC,
Okay.
not West Kentucky College. There's still a tax entity called Paducah Junior College that is the beneficiary of those taxes. And I think it's the smallest tax in the stack. It's a penny and a half for real estate.
And I assume that we took the inventory out of them, out of their tax, I should say,
We evidently removed that at
at the same time.
at some point. I don't know when exactly that happened, but the county removed it in 1998. It was a 4-year phase out.
It was at the same time they took it out.
Is that when it came out? Okay.
I guess sometimes, so who's going to send out the tax bill for the inventory tax?
The clerk does.
Is it going to be, does it make sense to not tax inventory in G, but tax it in D, E, and F? Is it
I
gonna be a
didn't
hardship on
take it
anyone?
out.
Huh? Say what?
I didn't take it out.
Okay.
It is, where it makes sense is in the college district, in the city, it's not taxed either.
Okay, so then we're matching the city.
Yes.
All right, okay, now I'm happy, sorry.
Okay.
I want to point out, too, that under I think it was a 2018 tax reform that the legislature did, they made local inventory tax, you can deduct that. It's being phased in, but by 2020 or 2021, businesses will be able to deduct 100% of their inventory tax from their state tax bill, state income tax bill, up to the amount that's due. They can't get a credit back for it if they owe more. But in essence, this change will have people paying that amount of money to the county rather than to the state.
Correct.
By 2021.
That's a good point. So I think for 19, it was 50%.
Right.
Next year it'll be 75, and then finally 100%. So if we don't have an inventory tax, they won't have any credit to take on their income tax.
Essentially, people in our county are going to pay this tax, and it's an issue one way or the other, and we either impose it and keep it here locally, or we don't impose it and we'll go to the state.
As long as they own.
Is that a fair
As long
assessment?
as they owe state income tax.
As long-
That's true,
If they don't owe state income tax, then they're gonna pay it in the state and the county.
So I think it pretty much depends on a case-by-case basis.
But it was, I do want to give Phil a shout out for good research. That was helpful in deciding this.
Right.
So.
Again, it's a washout, so businesses by 2021 will not be paying any more tax. They'll be paying to the county rather than the state.
Where were you, on discussion?
I think we're
Any more
probably
discussion?
ready to vote.
Yeah. All in favor, aye.
Aye.
Opposed, no. Carries. Is there any other business we have? You know anything? No? Motion to adjourn?
So moved.
Second.
Discussion? All in favor, aye. Opposed, no. Carries. All right. Got that Richard Root reception.